Alrighty, make your way in, have a seat, relax, take a breather. I'm going to have a great presentation. So I have Leah and Benjamin, I'm just going to welcome up to the stage shortly. Now, just a quick reminder, there is the app, so if you have any questions, you can use the app. If not, that's fine. I'll run around with a microphone at the end. So this session, we're going to be going through a practical guide that you all learn just around the current focus areas of regulatory or regulators and government agencies across AI risk management, technology deployment, and wider compliance obligations. I think this is going to be quite interesting, so I'm looking forward to it. So riding the wave of AI opportunity without a regulatory wipeout. Right, can we have a warm round of applause for Leah and Benjamin as they come up on the stage?
Thank you, and I hope we get bonus points for the Gold Coast theming there with the regulatory wipeout.
Thank you very much for coming to today's session. We know it's always a little bit risky doing something like this after lunch, so hopefully people have got enough fuel on board. What we're going to talk to you about for the next 30-35 minutes or so is trying to stitch together some of the challenges that we've seen from the clients and the organisations that we speak to. And what's coming up more and more is this idea of there's all these different issues happening across the business in terms of how we're trying to use AI systems, AI technology. We're trying to find different sources in terms of what's a good risk management approach, what are the issues in terms of current law, and also trying to understand what are regulators ultimately trying to do and where do we need to go to have compliant, efficient and ethical AI systems and AI solutions across the business. So with that in mind, we'll just quickly tell you about ourselves. My name is Ben DeMarco, lawyer by trade, worked here in the US and in the UK, focusing on technology disputes, technology law, privacy and insurance. I get to lead within WTW what we call our cyber and technology risk practice. So we do a lot of work with clients around strategy, risk management, insurance placements, controls, process and governance. And as well as what I do within WTW, I'm also fortunate enough to work with a number of different universities and peak bodies and trying to think about where are lots of these emerging issues going. Over to my colleague.
I'm new to WTW, but have worked with them for a number of years, so I'm legally required to call myself a reformed lawyer, but I do have a legal background with an international law firm and have also previously worked for a Big Four, so specialising in GRC consulting in those tech risk, cyber and privacy areas.
So I think if we're going to start with talking about the regulatory wipeout and the tensions that we're going to face, we have to have a bit of a step back and think about where is AI technology now, where are AI systems, where are they going? And this is from a paper from 2024, and what they were trying to do was they were trying to come up with a framework to categorise and talk about the emerging AI systems and also stitch together what it meant with some of the old systems around knowledge management, role processing, automation. And I really like the way they visualise this. So they talk about the traditional large language model, input goes into the LLM, we get some type of output. We then start to see more of these agentic AI systems where we're trying to put in place different forms of automation. We want to bring in a whole bunch of different data sources and different forms of stimulation. We're trying to do memory, we're trying to do different storage. But also this idea of the agentic systems we're talking about now are still constantly evolving. And there's this view that we're going to go to something that's more complex, something that's more cognitive in nature, and ultimately have different forms, be multimodal, lots of different services that we're bringing together, different forms of middleware, different forms of application. And that's the real challenge right now. AI isn't just a line in the sand where we know all the uses and everything. It's constantly changing, it's constantly evolving, and realistically this process has to continue for at least the next 5-10 years as we look at different forms of architecture and different forms of strategy. We also thought it was important to take a step back and think about how are we trying to use AI systems at the moment, where are the opportunities, and that's both with LLMs and some of these mixed AI technologies. And what you see the more you look at it is each organisation has a whole bunch of different use cases and a whole bunch of different drivers. So for a lot of tech providers, they need to embed AI in terms of their service offering. It's almost a bit of a pay-to-play. If you don't have an AI solution, then you're falling behind the crowd. But then as we kind of keep going, there's people who are looking at it in terms of internal management. So that might be how they're thinking about sales channels, how they build content. There's also a very strong cost reduction focus at the moment. So we talk about productivity gains, but a lot of the plans, the ROI is how is that going to ultimately save costs, which is going to have a workforce implication, as was talked about yesterday. Then we start to see a whole bunch of other issues in terms of all of these big data investments organisations have done over the last 5-10 years. AI is kind of the bridge to leverage that or to realise it. As you keep going through, forms of human augmentation, so trying to support services, trying to improve accuracy, trying to have different forms of validation, and then all the way to virtual assistance and accessibility. And the point I want to make here is each of these use cases are going to have different risks, and if we're trying to think about it from a legal or a regulatory perspective, it's so amorphous that we almost have to get back to these very broad principles, and you'll see it reflected in terms of what the regulators and what the governments have talked about so far. For our next slide, we thought we've got to be a little bit objective in terms of what we're saying to you. And again, I don't know about your organisation, but a lot of the chats we have with our clients, there is a bit of tension in terms of how we're realising some of these AI investments. And there's certainly some concern around, are these AI projects succeeding? Are they ultimately getting to a point where they're going to be viable, both in terms of a maximum product, but also in terms of the commercialisation? And from the chats we've had, there is a lot of common themes around some of these tensions. So there's a lot of talk around the fact that for these AI projects, there wasn't a great focus. It kind of got into the board layer very, very quickly, and people said, well, we've just got to run, we've just got to run. I've given you some information from a survey that was done last year, and it was talking about, I think it was about 200 people that got surveyed, and they said across their business, on average, they had 37 different AI projects and proof of concepts that they were working on. Now you think about that, that's on top of the BAU and everything else that the tech and the R&D teams are trying to do. You're almost setting yourself up for failure, and there was a comment in there that it's almost like throwing spaghetti at the wall and seeing what will stick. But then as you keep going through, some of the other issues are funding challenges. So a lot of people here, they might have set aside a little bit of money for these AI projects and investments, but when the rubber's hitting the road and they're needing to look at year 2, year 3, they've got to think about how does that relate with all of their other IT priorities, the things around cyber, the things around modernisation, and also in terms of how are they ultimately going to bring this through and have that long-term support and resource. I'm not going to read all of these, but the 2 others that I want to focus on is firstly success metrics. This has come up in a lot of the discussions that we've had where we didn't really know what was going to be the underlying metric to decide whether an AI project was going to be successful, whether it was going to go into the field, or what was going to be the internal criteria. If we think about that just from a tech project and a tech governance perspective, you're kind of setting yourself up for failure because later on you don't really have that objective baseline to follow through. And the last one that I want to mention too is that there is a fundamental accuracy problem with LLM architecture, and that's a discussion for a whole other topic. But if we're thinking about these modern AI systems where we might have multiple LLM queries or different forms of LLMs stacking on top of each other, you just, from a probability perspective, make that problem worse and worse. And there's a lot of discussion now around the fact, well, a traditional workflow, it's going to do what we want 100% of the time, but something for LLM, there is going to be confabulations, there is going to be hallucinations, there are going to be process problems. So does that mean that some of the use cases ultimately just aren't viable for what we need from an internal perspective? Then, taking that as kind of our bedrock and going forward, if we're going to think about the minds of regulators and the minds of government, we've also got to look at some of the societal concerns that they've been focused on. And this isn't just about large language models, because these things have come up since the 90s and the 20s when we've had different forms of automation and AI. But I do think right now some of these have kind of come up even higher. So the first thing is the poor ethical structures. We know about the behaviours of a lot of the underlying LLM providers. We know about the data scraping. We know about the lack of visibility, the lack of transparency. That creates a huge concern. We've got to think about it from a societal impact perspective. There is a big concern around displacements and job losses, and obviously that creates economic and other socio-economic challenges. We've seen already where we automate decision-making processes, there are lots of consumer harms, there are also lots of personal harms. And as we start going through this, you'll see there are other issues. So there's a lot of discussion now around sovereign risk, depending on where the AI system is located, who the supply chain providers are, also the local capacities and local industries that we need. And then starting to go into the issues around just the inherent imbalances between the users, the distributors and the developers of AI systems. And ultimately some of the financial frauds that we're already seeing from AI technology, some of the issues around theft of IP, not just when we're building the LLMs, but also all this data and sensitive information that we're chucking into them all the time. So all of those are sitting in the background, and then we start to look at where a government's going, where a regulator's going. And if you look at this both in Australia and globally, a common theme is we want a safe deployment of AI. And when we look at those types of things, it's about the ethical approach. There does want to be some form of transparency. This idea of black box that we just hope and put a finger in the air and pray it works, no government is happy with that. And also issues around the bias and I think ultimately accountability, because if we don't have some type of accountability that sits around this technology and it's embedded in critical infrastructure or other processes, we as the community ultimately carry the can for that. And there's a real realisation that with AI, if we let it run that way, we're going to have those long-term consequences. The other discussion is the fact that some forms of AI are going to be particularly high risk. So if we embed it into a traffic management system, some type of logistics system, some type of critical bit of infrastructure, or some type of government service, that's going to require a different approach to regulation, a different approach to frameworks, a different approach to risk management. And we are seeing that tiering pretty much come up everywhere around the globe. You're also seeing more the idea that this will be a key component of the STEM future. So how do we create these job opportunities? How do we create this local industry? And how do we make sure that we're letting people come through and not necessarily being cut out of the opportunities that it could bring? The other thing that I thought is really interesting to mention is we don't want to be duplicating laws. So all of the jurisdictions, including Australia, we're closely looking at what existing laws can cover AI, and we'll talk about privacy in a few of them later. But where there are gaps, we want to make sure those specific concerns, those specific risks and challenges are being addressed. And from there, we'll just start playing with the idea of how do you get a regulatory system that navigates these issues and challenges. You will get these slides. If you want the slides earlier, come find me. I'm happy to give them to you. So we did on this slide just a common list of all of the types of risk issues that we're seeing and all of the types of risk concerns that people are sharing around AI. There's some really good stuff that MIT and a few others have put out. But the thing I want you to understand from this is it's kind of becoming end-to-end. So the first one is obviously bias and discrimination, and that's just a bit of an output type of thing. Some of it is around the lack of transparency, so just not knowing what's going on. But then as you keep going down, we've talked about some of the things around data leakage, around connectivity risk, the fact that we want this mythical AI agent and AI assistant to touch everything, and we're assuming that's not going to be a problem from a data or a cybersecurity perspective. But we also go into a whole bunch of issues after that in terms of what's going to happen with the potential for malicious inputs, what's going to happen in terms of the accountability, what's going to happen in terms of the problem with users. And you see this in the education space, you see this across financial service industries. You almost have to be specifically trained now to work out when an AI system or an LLM is going haywire. And if you don't have all of those things joined up, we create a risk for the organisation, but also for all of the end users. And the last thing I've mentioned there is shared dependencies. So from a supply chain perspective, AI systems are really complex, not just the fact that they're changing all the time, but also what is the tech stack going to look like? How is it constantly evolving? So because of this, we've got this end-to-end component of risks, some that are internal and some that are external. Next slide. Again, most of you people are very much cyber-focused, so you will be aware of all of this, but the notion around what does AI mean from a cybersecurity perspective, we're still grappling with. The supply chain risks are really challenging, lack of visibility, lack of data controls, lack of understanding processes and third parties and fourth parties. Inherently, what we want these AI systems to do is be connected to everything. So how do you do it from a sandboxing perspective? How do you look at access management? I was having a chat with a CIO of a very large mining company, and one of his concerns was he has this view that all of his tooling just isn't going to work if they bring through some of these AI projects. So what does that future look like for a cyber-secure AI system? There are a whole bunch of unique exposures that AI have. We've talked about the model drift. We've talked about the issues around malicious inputs. We've talked about data leaking, data exfiltration. And also there's this real discussion around, well, what does the threat intelligence community look like? Because a lot of the traditional stuff we get is still talking about specific cyber risks rather than AI-focused cyber risks. So all of these issues we're going to have to navigate and we're going to have to put together over the next 5 years. Over to you, Leah.
Thanks, Ben. So the starting point for what the legal and regulatory landscape looks like is in Australia we don't have an AI Act. Now the likelihood is that we will have one in the near future based on the consultation and what has been said in the government's interim report, but we don't currently have one piece of legislation that tells us what we should be doing. We do, however, have a number of existing laws that predated, certainly generative AI, that were not designed with AI in mind, but intersect with AI. And the law that we're going to focus on for the most part is privacy, because it's in that space that we have the most guidance, both from what is in recent legal amendments and what the privacy regulators are telling us about how we should be managing AI to ensure that we're aligning with that framework. But if you're dealing with CCTV or workplace surveillance or any form of voice recording, in addition to privacy laws, you've also got to be considering surveillance laws. IP is obvious from a data scraping perspective, and there's been plenty of thought leadership around that. But the other one I just wanted to touch on briefly is around directors' duties, where we've had AUSCERT come out with their Mind the Gap report, identifying that the adoption of AI is amongst its licensees is very advanced, but that the rate of governance is not keeping pace with that. So we're increasingly seeing that with these traditional regulators and these traditional laws, that there are AI adjacent issues that are coming out to play. So the first example of this is in the privacy reforms that we saw at the end of last year. And what we've highlighted there is that there is an AI-specific privacy reform. Before the end of 2026, if you are using automated decision-making that's making decisions in relation to individuals that could affect their rights and interests, then you need to have transparency statements around that in your privacy policies and collection notices. So there's some time before that becomes law, and that's in recognition of the fact that if you're working with a financial services organisation or government or another large organisation that's dealing with all of these automated decisions in relation to individuals, it's going to take time to map and build out that transparency. But what we're seeing is that already that the Commonwealth government agencies are already making those transparency statements due to policy that's requiring that. We're also seeing from a best practice perspective that a lot of organisations are starting to bring out that transparency in procurement, in showing how they're delivering services. So we'll increasingly see shifts in that space, but that will become law at the end of 2026. I also do just want to briefly touch on, from an InfoSec perspective, the top left-hand corner there around protection of personal information. Another reform that's highly relevant for those in the room is APP 11 around the security of personal information is the one that most often intersects with the work that you do. And it was made clear in that legislation that the controls that you have in place, the reasonable steps to protect information, that must include both technical and organisational controls. So bear that in mind when you're building out how you're going to protect the personal information that may be used in these AI models. I want to now talk about regulatory priorities and how those intersect with AI. And biometrics is another really good example here. I'm going to talk about the Bunnings determination, which is where AI is intersecting with privacy again. Now, I went to a presentation yesterday where someone was talking about biometrics and saying, look, there's all of these requirements to protect biometric information, it's sensitive information under the Privacy Act, but it's not a passport, it's not a driver's licence, it can't be misused in the same way. And just from a policy perspective, a public policy perspective, the Privacy Act looks at certain types of data, sensitive information, and it gives them a special class within the Privacy Act. And the expectation is that you generally need consent to collect that information, and that there are additional restrictions that are placed around its use and that are placed around the protections that must be put in place. So when you're looking at what security is required, biometric information, other forms of sensitive information are considered to be the crown jewels as far as the Privacy Act is concerned. So I just thought it was important to explain that point, why that, and the reason why the sensitive information is so important is once there's an unauthorised disclosure of that information, there's not much you can do to fix it. If your credit card's stolen, you can ring the bank. If your driver's licence is stolen, you can get a replacement or put in place other protections. If your biometric or health or other sensitive information is stolen, there's very little that you can do to try and remediate that position. And that's what has this special place within the Act.
Just before we go on, the reason why we're talking about privacy in this context is it's the closest we've got to a live law. So the things we're seeing in terms of what the privacy regulator is concerned by, that's the stuff that you've got to have at a very high level when you're thinking about AI risk, but also that way that regulator is enforcing and how they're actually doing their investigations. We think it provides a really good guiding light in terms of what you need to do from an overall risk management perspective.
And in that regard, so this determination in relation to Bunnings is a great example because AI and biometrics obviously a close relationship there. So most of you would have seen this in the media, and I'm not going to run through the points there in detail, but what I wanted to address is that Bunnings was using this facial recognition technology, and they made it very clear they weren't using it to identify shoplifters or frequent shoppers or anything along those lines. It was a workplace health and safety measure because people were coming into their stores and attacking their customers and attacking their staff. That's the reason why they implemented these measures. And the Privacy Commissioner found that, okay, this facial recognition technology, it's collecting biometrics. You haven't done enough to seek consent to collect this. There isn't enough transparency in relation to your notices, and I'm not sure about the circumstances in which you're using it. So there was an adverse determination against Bunnings. When that was released, Bunnings have announced that they're going to appeal to the Administrative Review Tribunal, but what they did in the immediate aftermath of that determination being released is they released 90 seconds of footage where it showed their staff being physically attacked, people who had guns and other forms of weapons who were attacking their staff, and said, this is why we're doing it. How can we balance this workplace health and safety with these privacy considerations? And the other interesting point with the determination is in relation to those transparency and consent considerations. The Privacy Commissioner said, look, there's proposed privacy reforms around fair and reasonable use. These are not law yet. There's consultation that's taken place, but they're not law yet. And she said, we look forward to that becoming law. So we're seeing an active, forward-thinking Privacy Commissioner who's looking at the gaps in the law and working out how she can use her regulatory powers where there's an alignment with privacy to make those determinations. So stay tuned to see how that unfolds with that Administrative Review Tribunal appeal. But the other important measure is that when the Privacy Commission has released that determination, she's also released a one-pager. If you're using facial recognition technology, this is what I expect. So when you see these decisions and determinations come out, there's very clear regulatory statements around what you should be doing to ensure you don't fall foul of the Privacy Act.
And I think just before we go on, two concluding things that we'd say to look at here is the sensitivity of the data, because again, these same issues will play with a lot of different AI systems, and where there is that highly sensitive data, there's going to be greater scrutiny, there's going to be greater focus. But also in this case here, you'll see there was a tension between an internal use and what were some of the wider and some of the consequential issues. So you'd need quite a robust risk management, maybe like a privacy impact assessment framework, but something where you're trying to understand those issues early on so you can preempt and you can try and navigate these issues.
And whether it's fair to be scanning everyone's face who comes into the store when you're just looking for a small number. So what else can you do? We understand this is a privacy issue. We understand that we don't have an AI-specific law. What can we be doing to ensure that we don't fall foul of regulators or lawmakers in this space? The starting point is the AI Guardrails that were released at the end of last year. So in September, we received the voluntary AI safety standard, which offers practical guidance around what you should be doing for the responsible use and deployment of AI. And immediately alongside that release were the proposed mandatory AI guardrails. And I'll talk about those in a little more detail. But one question that I get a lot is, well, we've got all these legal obligations, we've got all these laws that we have to comply with. It's got in the name that this is a voluntary AI standard. Why should we use it? Why should we follow this? And the reasons are this. First of all, it overlaps with the mandatory AI guardrails. There might be some tweaking, there's a bit of consultation. I know, Ben, you've got a view on how that's going to unfold given recent cabinet shuffles. But if you're aligning with the voluntary guardrails, you're aligning with what the mandatory guardrails are likely to look like. So your framework might only need some tweaks when this ultimately becomes law. The second reason is it's relevant to Australia. It's been designed for Australia, our privacy legislation. It aligns with the 8 ethics principles that predated this, the NIST framework, ISO 42001. It's mapped to all of those frameworks. So if you use this as your starting point, you're looking like you're taking reasonable steps to protect data and to use AI responsibly.
Just before we go on, do you want to explain when something falls within the mandatory guardrails and when it will be voluntary?
What's that, sorry?
Do you want to explain when something falls within the mandatory guardrails?
So with the mandatory guardrails, they're going to adopt a risk-based approach. So if you've had anything to do with the AI Act in the EU, they've determined what will be high risk. And so in Australia, it's going to be the same. There's 2 different ways that the guardrails have been approached in relation to the development and the deployment of AI, and it's going to focus on that high-risk technology, the high-risk uses. So the idea is that low-risk AI that we've been using for years, where the consequences are limited, that will be allowed to continue without too much additional regulatory burden. Whereas if you're using these high-risk technologies where it's aligning with high-risk regulatory priorities, the mandatory guardrails you'll be expected to follow. And there were 3 different ways that these were intended to be released. Following consultation, it looks like it's most likely going to be a whole-of-economy AI Act. Did you want to comment on that, given the recent cabinet reshuffle, how that might unfold?
Yeah, so as many people will be aware, Ed Husic is no longer the Minister of Finance and Innovation, and he obviously had a very strong view about the need to bring through this holistic AI Act. So one of the things we'll have to see too is with the new minister, what are their priorities going to be? Is it going to be within the same form? But I think because this was still a Labor government initiative, ultimately we'll be following something relatively close to this.
So how do we bring all of this together? So Ben, I'll talk to you about how to address this, but what we've got at the bottom of the pyramid there is the hard laws. We've got those existing laws we know we need to comply with. So that's the starting point. We know we need to do that. But what else should we be doing to ensure that we have a best practice risk management framework?
Yeah, and I think for this slide, what we were trying to do is everyone's doing things slightly differently. So how do you take what different organisations are doing, how they're approaching it, and what you can take from whether it's governance or different strategies or frameworks? And what we've kind of seen is there's a bit of an end-to-end problem. One is we have to start with what's our overarching approach to AI, and people were talking about AI strategy documents, people were talking about AI ethics, fundamental AI principles, but there has to be some type of articulation of what is the priority, who are the stakeholders, what are the impacts, what are those types of key requirements. From there we can start to cascade down. So again, we're talking a lot more about forms of governance and process. Lots of organisations have got AI usage policies or elements to their acceptable use policies, also things in terms of process and things in terms of user training and staff awareness. But we're also going to have to start to think about, as I mentioned before, is what's the interplay between cybersecurity, but also the levels of resiliency, the levels of availability, because this will have business continuity and a whole bunch of other problems if it fails or if the systems fall apart. From there, we're seeing organisations trying to take the best from different types of standards, guidelines and frameworks. So there's obviously the ISO standard, you've got as well a whole bunch of stuff that the EU's produced. And what we're trying to see more and more is some type of an alignment of those, things like the guardrails, and trying to preempt or have a situation where we're able to comply with them. We've then mentioned the fact that there's a lot of the existing laws, so things like the consumer laws, things like copyright and so forth, and we already know the processes we should have in play for that. And lastly, as these AI-specific laws and legislations come through. So I think the 3 things we want to leave you with for this slide here is there should be something that's sequential and should be something that brings it all together. And you can look at the guardrails or other approaches, but we want something that's logical and something that's coherent. Secondly, there are low-hanging fruit and things we can do already, and we should be doing them at the start when we're thinking about AI projects or even when we've got AI projects that are halfway through the mix. And thirdly, we are going to want something that's got fancy footwork, because this will change, the technology will change, the legal, the risk and the governance. So this isn't going to be like a set and forget set of policies or processes and procedures. This slide's going to bore you, so I'm only going to do it in 20 seconds, but we do a lot of insurance broking and insurance placement. People are really terrified. What's happening with all these AI risks? Is insurance going to cover? Is it going to respond? The answer is a little bit, but there's lots of these emerging risks and challenges where the insurance carriers aren't sure what the exposure is, they're not pricing for it, the policies aren't affirmatively covering it. So even if something goes wrong, those traditional kind of balance sheet protections or risk transfer protections, they're probably not going to work here. And I think this is quite insightful because this is the challenge. A lot of the ways in which we think about overall organisational risk management, they're not fit for purpose right now for AI, and this will be a problem that will repeat, I suspect, quite a bit.
So this is the final slide we're going to talk to, and then we'll leave some time for questions. So this is a plan, an implementation plan for how you should be thinking about AI within your organisation and how best to ensure you've got those good governance practices in place. So the obvious starting point is in relation to the voluntary guardrails, the voluntary standard, looking to ensure that you're aligning with that. One challenge a lot of organisations we work with have had is they were quick off the mark. They aligned with the 8 ethics principles that predated the voluntary standard. So they've built out their AI policy, their AI strategy based on that. And while the voluntary standard builds upon those 8 ethical principles, it's far more detailed. It addresses broader subjects than just the ethical principles. And it also represents the current view on what best practice looks like here in Australia. So that challenge for uplifting the ethics principles to the voluntary standard is a common starting point for organisations. So aligning with that, but also really carefully monitoring the consultation in relation to the proposed mandatory guardrails. So at present, that consultation has ended, and the latest statement is that there's going to be a likelihood that there will be an AI Act, but that might change. So you mentioned the cabinet reshuffle, so just keep an eye on what's happening there and monitor any developments, because those voluntary standards are the first version. There's likely to be additional versions, particularly if there's a delay before the mandatory standards take place. And in any event, we know that the mandatory standards are only going to address high-risk settings. So using the voluntary standards in the low-risk settings will help to protect you as well. Something else that our clients have been talking about is data governance. So Ben, you mentioned data scraping, and the quality of the data that you input into these AI models is obviously going to have an effect on the output. So, and this aligns with privacy considerations as well. So making sure that your data governance practices identify that personal information and the subset that is sensitive information, and ensure that you've got your consent management in place, ensure that that data quality aligns with your obligations under the Privacy Act, and that you understand that provenance, particularly when you're thinking about that from a consent perspective. Also, looking at data minimisation. So data minimisation has been a topic that organisations have been talking about really since the watershed events of 2022 with Optus and Medibank and those other significant data breaches. But what we have seen is it's really been in the last 6 to 12 to 18 months that organisations have started implementing and taking that data minimisation seriously. So before you've got a data set that you're going to input into one of these models, looking at whether you're if it includes personal information, are you allowed to keep it? Is the purpose for which you collected it still valid? Have you got a secondary purpose for which you can continue to use it? Do you have any statutory record retention obligations? And tidying up that data minimisation and that data quality before you're inputting these large data sets into an AI system. And the final do now, because this is a security conference, is around taking those reasonable steps to secure data. So that's looking at your existing InfoSec measures and whether they're going to adequately protect those systems, but also tying this back to privacy, thinking about those technical and organisational measures, the fact that you now need to include both when you're looking at protecting personal information. What do you do next? Adopting that strategic approach. So ensuring that when you're developing your AI strategy that's consistent with your organisation's existing strategic goals and values, that aligns with the strategic directions that are in the voluntary standards, but also leveraging those existing risk management systems that you have in place to ensure that you're adopting a very strategic approach. So privacy impact assessments, a really good example of something that was potentially going to be made mandatory under privacy law reforms, but it didn't happen. But I can tell you every single data breach that I am involved in managing, the OAIC will always say, where was your privacy impact assessment before you undertook this activity? So voluntary alignment with privacy impact assessment requirements, thinking ahead to internal audits. Did you want to talk to that one, Bev?
Yeah, I think what's interesting now is we're still at an early stage with these types of projects, but ultimately we are going to want to check the governance. We're going to want to check how it's been implemented and delivered. And we see with some of our friends that are in the audit space, in the cyber assurance space, they're talking more and more about the AI projects and how they're coming through. So what are we documenting? How well do we understand the scope? How do we understand the providers, the system flows, and so forth? So we think that's something that you should also start to think about, and ultimately having that documentation and proof, because it's very hard to build after the fact.
And that final item there is around that new AI-specific privacy requirement in the privacy amendments that were made at the end of last year, with that 2-year runtime before that becomes law. So if your organisation has significant automated decisions, be starting to map those decisions, be starting to voluntarily align with those transparency requirements, and also look out for other transparency requirements, whether it's in the voluntary standards, whether it's in that policy at a Commonwealth level. Transparency is increasingly important from a governance perspective. So we'll leave some time for questions now.
Lovely. Thank you, Ben and Leah. Can we have a round of applause? It's an interesting topic, and it's evolving quite a lot. And I noticed in one of your slides there, you had the Biden executive order around AI, which has just been recently repealed, right? So my question is more just around 27 million people in Australia, and we're seeing, potentially some laws changing around AI, over the coming years with the, repeat Labor government. We're seeing the EU doubling down on some of the AI privacy. We're seeing Southeast Asia as well, across Singapore and Malaysia and whatnot. In your opinion, do you think that collectively there's enough power in order to change the practices of some of these companies, given that it's coming out of the US or coming out of China predominantly as the AI powerhouses? Do you see change actually happening?
I think that what is challenging, and one of the issues that you're pointing to here, is that the law is struggling to keep pace with the rate of technological advancement. So we've already seen that here in Australia. We don't have an AI Act. We've got some voluntary standards. We're playing catch up. Even from a privacy perspective, we still can't push through all the privacy reforms we've been talking about for more than 5 years. I think there's going to be challenges with that extraterritorial application. So from a legal perspective, we really need to be, China or another country really needs to be reaching into Australia, collecting the data of our people, or manufacturing or selling products here for them to come within the scope of our laws. And if we have a situation where Europe is leading the charge with the gold standard of AI laws, where the US wasn't doing particularly well and is failing in that space, we're going to have a global regulatory and legal framework where it's not consistent. And so organisations, I think, are going to find it challenging. But what we have seen is that regulators will step into the breach and will find ways to try and make determinations where that pace of law or where those inconsistencies or extraterritorial issues make it challenging.
I'll just add two things. The point you're raising isn't just AI, it's big tech generally. Because the argument is we haven't really effectively regulated them. Yes, there's billion-dollar fines, but they still keep going on with these types of terrible practices. So we won't solve it in the context of AI. It's going to have to be a much wider discussion. But what I'm finding quite interesting is, particularly for clients that have more of a global footprint, they're trying to work out what's the high watermark, because there's no point for them if they've got different processes for AI in one country or another. So I think you will find people deciding, well, we think this is going to be the high-level requirement for the next 5-10 years and matching to that, because otherwise you just have to keep ripping up your internal processes.
Yeah, fantastic. Thank you. We've got time for a couple more questions. So if you do want to ask a question, just raise your hand or submit it in the app. So I'll read this out, and I suspect I know the answer for this one, but it's more of a statement and observation. So you made the comparison between credit card data and biometric data, and made the point that you can change your credit card number in your presentation earlier. But do you not think that might be a false equivalence, given that we put our faces on LinkedIn and Facebook, and our faces are captured and stored by hundreds of cameras everywhere, yet this is not considered sensitive information, but in the Bunny's case, it was considered?
It was the fact that it was that facial recognition technology was going beyond just an image, which is not an image of an individual, a photograph of an individual, CCTV. That is not collecting sensitive personal information. It's not collecting biometric information. It's just collecting personal information. An image of your face or my face, that's not going to meet the definition of biometric information under the Privacy Act. The challenge with biometric information is where you have the technologies that are collecting that. It can also reveal other forms of sensitive information, such as cultural backgrounds and the like. And you might say that that's evident from photographs, but it delves in deeper. It collects and uses this additional layer of information, and that's why it's such a regulatory priority.
Yeah, and I think people slightly misunderstand biometrics. So I worked in the US on cyber frauds for a number of years, and I remember one of the big ones we worked on, it was essentially US Medicaid fraud. And the idea was, if I knew about someone, I knew about all their vulnerabilities, procedures and that type of stuff. If I was a third party, I could plug all that in, make fraudulent claims, get the money, and then they'd kind of have to pay it after the fact. So you can actually leverage biometrics in a lot of different dangerous ways that we don't always think about.
I suppose it's also about consent as well. Like
Yes.
if you look at any of the major supermarkets, there's, you know, cameras everywhere that track how you shop. You have no choice but to go to those. So the next question, you mentioned business in addition to technical controls. Can you share more on business control impact?
Sure. So those organisational controls, the reason for that is that when you get the notifiable data breach report that the OEIC releases every 6 months, generally speaking, the main cause of data breaches is a malicious intrusion by a third party. But the second biggest cause, most reports, is human error. So the intention is you shouldn't just have a cybersecurity, you shouldn't be aligned with a certain maturity within a cybersecurity framework and have other cybersecurity controls in place. You also need to train your staff. You also need to ensure that you have policy in place that makes it clear how you're allowed to use information. So it's intended to capture that human error and also to bolster the security measures that are in place.
Yeah, fantastic. And that's it for time. Can we give a round of applause to Leah and Benjamin, please?